This is Colin O'Keefe checking in here again for LXBN TV in what represents a big win for employers. The Supreme Court unanimously ruled earlier this week that Amazon warehouse workers do not need to be compensated for the time that they spend after work in security screenings. Joining me now to explain the ruling, what happened with it, is attorney Doug Haas. He's with friends at Reddit in Chicago and also author on the firm's blog, Wage and Hour Insights. Doug, I've read through a lot of the analysis of this case, but a lot of people are still kind of struggling with the concept, so maybe you can just explain it in basic terms. Why exactly are employees not paid for these security screens, which, of course, as mentioned, they are obligated to participate in as part of their jobs? Why is that not compensated time?
Well, and that's the test that the Ninth Circuit actually used in the case of the Supreme Court was considering, Colin. And their test had focused on whether the employer required the employee to engage in security screenings or any other particular activity. And the Supreme Court said that kind of divorces the standard from what's used in the FLSA regulations themselves, which says that this has to be integral and indispensable to the principal activities, and in particular, the performance of productive work. That's the phrase that the Supreme Court looked at. And actually, Justice Thomas's decision gave non-legal HR people or even lawyers a really good test to use, just a simple practical test, and said, what happens if we completely eliminate, in this case, the security screenings altogether? Does it impair the safety or the effect principal activities, which in this case was to locate and pack items for Amazon shipments? And the court said, in this case, no. If integrity staffing had completely eliminated those checks, it wouldn't have really impacted the employee's duties at all. Another common example would be employees who, for whatever reason, are required to park at a remote lot or some distance away from their normal place of work, and then they are taking an employer provided shuttle into their actual workplace. They're not compensated for that shuttle time, even though the employer is the one requiring them to park out in this remote lot and take the shuttle bus in. Again, it's not really related. It's not integral and indispensable to their principal duties. It's not in any way related to that, the performance of productive work. And that's the real distinction that the FLSA regulations draw, and the one that the court highlighted in its decision.
I see. Yeah, there really does seem to be some clear-cut language in the FLSA, and that's why this ended up being, a unanimous ruling before the Supreme Court. But second, when you have, workers that might, want to be, compensated for this time, what is the traditional recourse on something like this? Is it really expected that it's, this type of thing is resolved in terms of, labor negotiations? What normally happens in situations like this? What's the recourse for the workers?
Well, the recourse really depends on what kind of time we're talking about. If we're talking about compensable time, the FLSA says it doesn't matter if you have a collective bargaining agreement or an employment agreement or some other policy that says that time's not going to be compensable. The FLSA says it doesn't matter. The FLSA will control and make that time compensable no matter what. When we're talking about non-compensable time, like security screenings, like employees taking a shuttle bus into their actual work area, the court in dicta said that these kinds of issues really are properly presented to the employer at the bargaining table, whether that's collective bargaining or just one-on-one bargaining between an employee and employer, rather than in an FLSA claim. The FLSA really doesn't cover this kind of activity, and the court sent a clear signal in this unanimous decision that those are really private matters between employees and their bargaining representatives and employers, like the staffing agency in this case.
Mm-hmm. Absolutely. That makes a lot of sense. The FLSA is just, there to govern what absolutely must be compensated, but that doesn't mean that these employees can't be compensated for their time. It just ultimately comes down to, what happens again at the bargaining table, whether it's, union negotiations or one-on-one negotiations on compensated time. Well, once again, that was attorney Doug Haas of Friends at Reddit with that great explanation of this ruling. For more of his insight and his written up breakdown of the case, be sure to visit WageHourInsights.com. Thank you for joining me again, Doug.
Thanks, Colin.